welcome to Patent Effect Podcast, new episodes. This is the rainy Berlin today, and after -8 and -9, we have a good weather but rainy in Berlin. And today I have very distinguished colleagues and friends from different countries who are very distinguished IP litigator in a worldwide known in the IP ecosystem. So I have two guests from Germany and Turkey. One is Okan Can, and the other one is Dr. Kaya Köklü. Welcome to our episode.
Thank you for inviting us.
Thank you very much.
Thank you so much to be with us in this podcast that we are recording in English to talk about insights and strategies about preliminary injunctions in patent litigation in a perspective of different countries, and particularly Germany and Turkey. So I'm really happy to onboard you in our podcast to discuss this very, very important topic, especially in European countries. But we need to listen. We need to learn about some tips and tricks and important points of preliminary injunction topic in patent litigation. But first, in the IP ecosystem, both in Turkey and Germany, you are well-known IP litigators. So in the ecosystem, so I know lots of our audience and listeners already know you in person. But I would like to let you introduce yourself in a short position. Maybe we can start from Mr. Okan Can. Also, I would like to express this information that we are recording this podcast in the sponsorship of DERIS patent from Turkey. So welcome again, Okan, and then please let us know about you. How did you start this patent business? So what are the verticals that you are getting experiences in patent litigation and different topics of IP? And stage is yours. And then I will jump to Mr. Köklü.
Thank you, Mustafa, for having us in this podcast. Just a brief information concerning DERIS. We are an IP law firm based in Istanbul with approximately 85 people. Our team comprises of mainly IP litigators, European patent attorneys, patent and trademark attorneys, and the supporting teams. We represent clients from all over the world and provide every service concerning IP, from prosecution to litigation and to transactional work. And besides these practices, we do also have a growing data privacy practice. And coming to me, I am one of the senior partners at DERIS. I have worked as an IP litigator for more than 20 years in the field. And I deal with all type of trademark, copyright, and patent litigation, IP strategy, and technology licensing. I am also one of the members of the board of directors at INTA, namely the International Trademark Association, and I have been recently appointed as the board member for the Global IP Alliance, which is established in Atlanta. So I'm very happy to be here with you and Kaya for this exciting topic.
Super. Thank you so much for being with us in this topic. So, Mr. Köklü, you are in Düsseldorf, right?
Yeah, I'm in Düsseldorf, very close to you, almost close to
almost
you.
Close. Almost close. How was the weather? How is the weather now? Is it rainy or?
Since I think a couple of months already, it's always gray, wet, rainy. Yesterday it was quite cold. So I think we sent you our ice rain to Berlin.
Yeah, it was the -9 2 days ago. So thank you so much for accepting our invitation to be part of this episode. So I need to ask you as well the same question. Who is Dr. Kaya Köklü, and what are your experiences? What are your profession, and which kind of verticals in IP you have an expertise in Germany?
So thank you very much for having me here in this round. some people may already know I'm an IP litigator in Germany, located in Düsseldorf. I'm working with Tigges Law Office in Düsseldorf, working in various fields of IP law. This is not only patents, but also trademarks, designs, and copyright disputes. I started my IP profession, and Okan, you will confirm we are getting old somehow. More than 22 years ago, in fact. I started with a PhD in a comparison of Turkish, European, and German patent law. So these were my first experiences in IP issues. So this is my focus, litigation, yeah, and I'm also a panelist for international domain name disputes at WIPO. So I have there frequently appointed as a panelist. Yeah, and I'm happy to be here and to discuss the preliminary injunction topics.
Super. I'm really exciting to discuss this important topic. As we know that in Germany, this is a really important topic. And today we will discuss this topic in the two perspective, in the German perspective and the Turkish perspective. But first, we need to understand the first question. What is the preliminary injunction in patent litigation process? I think we have to describe the main topic. So coming from macro to the micro, and which one of you would like to start to give this the basic question?
Okay, so a preliminary injunction is a temporary and not a final court decision. Yeah, and it is a very efficient way to protect intellectual property rights. Yeah, and whenever it's urgent and the IP owner cannot wait until there is a decision in proceedings on the merits. Yeah, this is a very powerful but also very important tool to safeguard the interests of IP owners, and therefore it's also relevant not only in patent but also in trademark, copyright, design right issues. Yeah? But there are some special things we have to discuss for patent preliminary injunctions, and I think the first roots of international obligation to introduce these kind of efficient protection is the TRIPS agreement, which is also signed by Turkey, right, Okan?
Yes, yes.
On this perspective, in the definition of the preliminary injunction, is there any major differences between the Turkish law and German law?
I think so that in reality this is an requirement or it's an tool coming from the civil procedural law, and the civil continental law is a little bit similar to each other. But when we come to the evaluation of the merits of the patent disputes, it's different, of course, from one jurisdiction to another. But with regard to the basics, I think it has the same, let's say, similar approaches, like there should be an imminent risk, there should be a threat, or there should be an infringement, which meets as a condition for asking an infringement. So I think in that sense, this is something that's similar between the two, let's say, jurisdictions.
Yeah, I fully agree. I fully agree that the requirements in general are very similar to each other, but there might be some differences in the application by the courts. So the practice might differ to some extent.
Super. So maybe we need to talk about the importance of preliminary injunction during this patent litigation process. Why are we talking this topic? So why this preliminary injunctions process really important and crucial for the patent litigation process in both countries?
I think it's
I think it's not important only for these two countries, but it's important for all, globally, for all countries where they have, yes, where they have a patent, let's say, protection system. And I think it's more important with regard to the patents because of the fact that the patents have a limited protection date, uh, and it's a monopoly actually. For it gives a monopoly to the patent owner to utilize its patent rights. So during this period, the patentee would like to enforce his or her patent as much as possible for and for an let's say for the most efficient in the most efficient way. So in such cases, and considering also the fact that the patent trials are taking a long time, at least for Turkey, then the evaluation of the preliminary injunctions become more important in the patent disputes compared to the other rights. So the patentee would like to see some measures which will provide the tool to exclude the others or to stop the other party to infringe the patent rights during this time.
So I think for our listeners can be quite understandable if we can go forward with giving an example. For example, maybe we can create an example of the litigation case, and then when the patent owner should apply for preliminary injunctions, or how they can proceed the other steps. So we can easily talk about these topics by one way to describe better imagination. Uh, for example, in Germany, I have a European granted patent validation in Germany, and I have a patent in Germany, and I will join the trade fair in Germany. But one of my component is infringing one of the company's patent, which is already granted in Germany. So, and the company has already noticed this infringement. So, in this case, how the process is starting for the patent owner in Germany to treat me as a participant, or the exhibitor in the trade fair. So, what is the position of preliminary injunctions in that period, and when should the patent litigation process should start? Maybe we can combine these kind of dimensions in one case. Can we do that?
Yes, of course. And the example you have provided now is a perfect example because it's the most common area where preliminary injunctions are applied, particularly in patent disputes. So just imagine the trade fair situation. So Germany is a venue for a lot of internationally leading international trade shows. Yeah. We have Medica in Düsseldorf, we have the IFA in Berlin. So there are a lot of internationally well-known trade shows which are also attended by, for example, Turkish companies, yeah, in large numbers. And just imagine that you realize on a trade show which lasts, let's say, 3, 4, 5 days, yeah, an infringement by a competitor. Yeah. And just imagine that there is no option of a preliminary injunction, yeah, then you would have to accept that someone else from any other country, or even in Germany, a competitor, infringes your patent during the trade show and harms you in your business. Yeah, and he can even do so deliberately. Yeah, just imagine such a situation, and to prevent this, to give the patent owner an efficient tool, yeah, to combat these kind of infringements, particularly the obvious ones. Yeah, there is the option of having a preliminary injunction application, and then you can file it with electronical means, meanwhile, in Germany. So the court system is not so modern as in Turkey. Yeah, but we now have started with electronical means, so we can file applications via a certain electronical system. And it then really depends on how good you have prepared these applications. So it might well happen that the court grants such a preliminary injunction during the term of the trade show, so that you can serve the injunction, yeah, during the trade show to stop further displaying the IP infringing, patent infringing product during the trade show. So it can be a very powerful tool, but you have to be very careful how to draft and how to prepare such an application. But I think this is very comparable and very similar to the Turkish situation.
Okan Bey, how do you think about this process when this patent owner is infringing anybody's patent in Turkey and he's participating in a trade show as an exhibitor or visitor, and how this preliminary injunction process is going on in Turkey? Is it also is it possible to also apply electronically before the trade fair? So how should I need to go forward?
Yeah, I think we do not have the electronic system as Kaya mentioned, as they have in the German system, but we do have other tools for deterring the patent infringement during the fairs, because as Kaya mentioned, it's a very short time. You need to go and enforce your rights or give the message that you are protecting your patent rights. So we do have different tools rather than the preliminary injunction in the Turkish system. I think I can evolve the question into another possibility where there is an infringement in a premise in Turkey, and this is actually on how it usually comes to us. And let's think that there is an infringement at a premise in any part of, let's say, Turkey, and this is infringing the rights, and it gives damage to the patent holder's rights. So in such case, for making, you have different ways of asking a preliminary injunction in Turkey. You can file it as an independent application, or you can ask it within the context of a main infringement action, or you may file an evidential action and file it as a part of the evidential action. So these are all different, let's say, possibilities for claiming the preliminary injunctions. But in Turkey, especially if you have a sophisticated technology with regard to a patent which has been protected, which is protected in Turkey, we usually start with a main infringement action plus a preliminary injunction. And in this case, the court will usually not be acting within the context of your evidences. And usually in the patent infringement cases, the court will want to hear the adverse party as well, since this technology needs to be discussed. And also, due to the fact that the Turkish systems do not have the judges with the technical backgrounds, the judge or the Turkish IP courts would need support from the court-appointed panel of experts to determine the infringement. And usually the court will be considering to order a preliminary injunction only after the issuance of the court-appointed panel of experts report. So this is something that the courts in Turkey would consider before filing, before accepting an PI order.
So, in the Turkish perspective, so you gave us very good good examples and insights, Mr. Okan. And also, I would like to turn back to Mr. Köklü to ask about the essential conditions. What kind of conditions should I observe or should I have to apply preliminary injunction request to the court? So maybe we can talk about these conditions.
Sure. I mean, the requirements for having a successful preliminary injunction applications are threefold. So first, there must be no reasonable doubt on the validity of the patent. So whenever you apply for a preliminary injunction based on a patent, it should be rather safeguarded that this patent is valid. So either it has already survived opposition proceedings or invalidity proceedings, or you have at least good arguments to show there are no doubts that the patent is valid. Second, the infringement action which you want to have to stop, this should be a straightforward case. It might be a complex, but it must still be a straightforward case. So it must be obvious that the party is infringing your patent. This requires a feature analysis and an infringement analysis, but you can do so within a preliminary injunction application if you are prepared well. And the third one, and in my view also one of the most important ones, is urgency. So you have to demonstrate to the court that the matter is urgent and that the patent owner cannot wait for a decision in proceedings on the merits. So there must be somehow an interest that you have a temporary order by the court. And this you can do by explaining the court that the damage which you may suffer is significant on the one hand, and from the timing perspective, you have to demonstrate that you have not delayed the application for a preliminary injunction. And this is often something which is not very easy for the patent owner, because the German courts are quite strict. They just apply these preliminary injunction proceedings if not more than 1 month have passed since you obtained knowledge of the infringing conduct. Some courts are more flexible in this regard. Some courts are very strict. But in any case, you have to demonstrate that you have not delayed the case and that the matter is very urgent for you. And if you can demonstrate all these requirements, then you have a good chance to get such a preliminary injunction order on quite a short notice. And it is not quite common to also ask an expert. So the courts rather decide without asking or involving a court expert.
I think I can take it from here to add something to Kaya's, let's say, explanation concerning the period. In Turkey, we do have an requirement of the imminent risk in the general procedural law. But when it comes to the IP code, the IP code says that the IP holder can also ask an preliminary injunction for providing the effectiveness of the ruling. So this is another criteria which is specific to the IP litigation. And to my interpretation here, the imminent risk is more flexibly evaluated with regard to this condition. Coming to other preparations and the conditions, you need to have a valid protected right in Turkey, a patent right. And what I see from my experience with specific to the Turkish practice is that the problem with the translation of the patents. So this is sometimes becoming an important issue for the patent holder. So if there is any vague or let's say errors in the translation, this becomes as an important matter during the enforcement of the right. And of course, this affect also the issuance of the preliminary injunction at the outset of the litigation. But in any case, we need an expert examination for the evaluation of the PI request.
I think maybe we can also think about the differentiation of these procedures in different sectors, different industries. For the patent litigation, for patent application, even patent application, the strategies in these steps are changing in different industries, like drug industry, life sciences, automotive, mobility, and energy sectors. So, in terms of these dimensions that you already explained about the procedure, conditions, requirements of the preliminary injunctions, are there any essential different, the perspective approaches of requesting preliminary injunctions in different industries such as life sciences and automotive in the world of standard essential patents? So the world is, in fire of all the patent litigations in standard essential patents in the automotive industry. What do you think about that?
I think this is a good question, especially to see on how the court's reaction would be with regard to different technologies or different sectors. So taking it from the SAP perspective, I have been involved in some SAP licensing negotiations in the past and in some SAP evidential actions, and also in one invalidity action concerning an SAP. But so far, I can say that Turkey has no ruling concerning the preliminary injunctions for the SEPs. The court's approach towards the injunctions, therefore, is not yet known to us. So, however, I can say that there is currently no prohibition or precondition for the patent for the SEP holders to ask for a preliminary injunction at the outset of the litigation. And we do not, since, in the absence of any case law or any regulation currently, these can be discussed at the outset of the litigation. So far, to my knowledge, we have only one competition board decision in this respect, but that is not concerning the preliminary injunctions. So I think with regard to the SEP, it will be interesting to see what the Turkish courts will say. Coming to the other areas, as I mentioned, we have many litigation concerning the life sciences in the life science sector, and also in the machinery, like in the textile machinery or in the other sectors. And with respect to these areas, the court's approach would be more to see what the panel of experts says. What I see from the court's approach is that the court, when there is a substantial evaluation by the panel of experts concerning the validity of the patent plus the existence of the infringement, then the court will be very inclined to grant an preliminary injunction. But this time, sometimes the courts may be a bit more reluctant to issue the decisions, the PI orders with regard to especially in the pharmaceutical litigation, and they would wish to see exactly the validity and the precise infringement to be assessed by the panel of experts before ordering an PI decision.
So before going to Kaya, maybe Okan, can you also confirm that this kind of preliminary injunctions and other litigation issues are mostly occurring in the life sciences, especially the pharmaceutical area in Turkey, right?
Yes, we do. The majority of the litigation are in the life sciences sector. This is we do not have an exact data about that, a central data in Turkey. Yeah, but from what we have been, let's say, experiencing with the local courts in Istanbul, we understand that there is a big amount of life sciences litigation, but also we do have an important number of litigation for other areas, like for the machineries, for the chemicals as well, and the textile industry. So these are the other industries where we do have also much litigation. Yeah.
Yeah, there is a huge market in this specific areas as well. So going back to the Germany, what is the German's practices? What do you want to say, Kaya?
In theory, a preliminary injunction application is available for all technical and business sectors. Yeah, so from a theoretical point of view, any sector can claim such a preliminary injunction. But for standard essential patent owners, it will, of course, be rather difficult to get a preliminary injunction because they have to first demonstrate that they are in compliance with the FRAND terms, so that they offered a license to FRAND terms, which already requires some time. And I'm not really sure if it is very easy for someone who is in fact not really interested in an injunction, but they are more interested in licensing. Yeah. So the owner of a standard essential patent rather wants to have license fees and not the injunction. So they will also face a problem with the proportionality of such a preliminary injunction request. Yeah, to stop the sale of, let's say, a smartphone which comprises 3,000 or even more standard essential patents, and if there's just one standard essential patent which has not been licensed yet, is it really proportionate that the sale of this product will be stopped instead of filing ordinary court suits to get the license fee they want to? But I agree with Okan, in life sciences, the courts are more open to grant the preliminary injunctions, just as maybe an illustrative case. Just imagine that shortly before expiry of the patent, of, let's say, a pharmaceutical patent, a generic company enters or tries to enter the market, let's say 6 months or 1 year before patent expiry. If the patent owner would only have the chance to file ordinary proceedings, so proceedings on the merits, you couldn't stop the competitor to enter the market because these proceedings will last more than 1 year. So in these cases, it's essential to have a preliminary injunction. And there in these sectors, it is, I think, more common to grant preliminary injunctions. But maybe, I don't know if we come to this topic also, rather against the security payment for the enforcement.
Yeah, you also indicate some of the keywords about the licensing issues. So in the last week, we heard two different licensing cases about the standard essential patents between Apple, Huawei, and Ericsson. Ericsson and Apple signed an agreement. Huawei signed an agreement with the other company, Oppo, which is also another litigation case in Germany. So if had time in this episode, I would directly push the topic to the standard essential patent, which is very hot topic and very exciting topic for me, for also you. But I need to continue on our outline. But I believe that we will see so many different licensing or cross licensing agreements in the standard essential patents between different companies in terms of 5G and other connectivity technologies.
Yeah, particularly, maybe one thing to add, particularly in the connected cars sector. Yeah, I can report from a case in Germany. The regional court in Munich, I think, granted an injunction. I'm not sure if this was a preliminary injunction or it was not, but against the security payment of I think 230 million euros. So this was the security payment to enforce the injunction. Yeah, it's a hot topic.
Yeah, it's our topic. So there are other components of the litigation process. So there is the patent opposition, invalidity claim. So maybe we can talk about the how this preliminary injunction process is affected by different other procedures like patent opposition or invalidity claims. What do you think this topic, Oka?
This is also an important, let's say, element which affects the preliminary injunction orders. Let's assume that, especially in Turkey, I think that's a different also practice from the German practice. Perhaps Kaya will be telling about that. But in Turkey, when you file let's say, an patent infringement plus a preliminary injunction decision, request, then the adverse party will be responding to your claims, plus they will probably counterattack you through an invalidity action. So in this case, the matter becomes more complex, and therefore the court would need to see whether the patent holder's patent is a valid patent, plus whether there is an infringement. So in this case, these two evaluations should happen at the same time, and the court will probably first ask the panel of experts to evaluate the validity of the patent, the invalidity claims, and then move to the infringement claims. So this is on how it will be affected. So if the patent is considered as an invalid, let's say, patent by the technical examination, then the PI request may have low chances of success in such case, even if the infringement is determined by the panel of experts. But with regard to an opposition, a pending opposition, that's also another case. If the patent holders has a patent which has passed an invalidity test in any jurisdiction, or if it has received any opposition and successfully survived after this opposition, this will show that you have a strong patent which could be enforceable. Therefore, the counter attack will have less effect on your PI request. But sometimes, and I think in majority of the cases, you have a patent which has been granted as an European patent, but there is an pending opposition against the European patent, and yet you try to enforce it in Turkey. So in this respect, you should look whether the scope of the patent has changed or not during this opposition stage or the appeal stage. So when the scope of the patent claims are changed during the opposition period, so it becomes a question mark for the Turkish court on how to evaluate the scope of the patent with regard to the infringement. So that becomes like it becomes as a question mark, and it usually the court will be focusing on the specifics of that case for ordering the PI. So there are different scenarios in each case. And now in accordance with the Turkish practice, we do also have now the post-grant opposition for the nationally filed patents. So that's also bringing another angle to the patent disputes.
Exactly. So what is the perspective of in Germany, Kaya?
It is very similar to the Turkish perspective, I would say. So the court who is deciding about the preliminary injunction decision, the order, should have no serious doubts on the validity of the patent, as I already mentioned. And if this is the case, then they simply take it for granted that the patent is valid, particularly if it survived in opposition proceedings or if it survived an invalidity action, or if the patent owner can really demonstrate that there is no new prior art which has not already been considered in the granting process. Yeah. So if, for example, the defendant in a preliminary injunction proceeding does not come up with new documents and cannot really uh, cause serious concerns about the validity of the patent, then this argument will probably not really be considered by the court. And if then the infringement is also quite clear, yeah, and urgency is giving, then the injunction may be granted on a very short notice, even. Yeah. So it can be granted within a couple of days, sometimes even within a couple of weeks.
This is really great information. Maybe we can also combine this part with the appeal process. So in this preliminary injunction orders, how can we say that appeal procedures can be implemented, or is there any appeal procedure for these preliminary injunction orders requests?
In Germany, it rather depends on what kind of preliminary injunction has been granted. So, if it was an ex parte uh, injunction, that means a preliminary injunction without oral hearing, yeah, then the defendant can file an opposition against the court order. Yeah. And once the court confirms the preliminary injunction, then they can file an appeal going to the higher regional court. But this is the final stage. Yeah, so there is just one appeal opportunity. Yeah, so you can file the opposition. If it was an ex parte injunction, and then you can file an appeal with the higher regional court. And if it was just after an oral hearing, yeah, then you can directly file an appeal with the higher regional court. So these options are given. Yeah, the prospects of success depend on the individual circumstances of the case, whether the defendant can raise any concerns concerning the validity, the infringement, but also often as regards the urgency. So there are preliminary injunction decisions, yeah, which will be lifted just because of a lack of urgency, yeah, which comes up in the appeal proceedings, yeah, where the court said, hey, this took more than 1 month, or the application was delayed. So even if the patent is valid and even if we agree that there is an infringement, we don't see the urgency and the decision will be lifted.
In Turkey?
For Turkey, of course, we have an appeal procedure. So after the issuance of the PI order, actually, if the PI order has been issued in the absence of any party, then the other party would have the a right to object before the same court against this. This objection will be heard in a hearing between the parties, and therefore the objection is at first level. It's being evaluated during a hearing. And secondly, if still there is an decision ordered by the court, this will be can be appealed before the regional appellate court. So, and the decision of the PI, the regional appellate court, will be actually the final one. Recently, we received a decision. It was an interesting decision by the regional appellate court. The court, it was in a very highly sophisticated, complex case, and the court decided to reject the PI order. And then the adverse party objected the decision, and the appellate court said that I acknowledge every aspect for the rejection of the PI request, but the appellate court said to the first instance court that it could order a reverse injunctive order, which is to ask the defendant to deposit a guarantee amount against a possible damage of the plaintiff. And therefore, the file was back to the court, and the judge ordered an reverse PI order by asking the defendant to deposit an amount of guarantee at the court. So that was an interesting recent appellate court decision.
Maybe we can also combine this process with the protective written submission. So, is there any what can we say about the importance of, or the procedure of, protective written submission in this process?
I think this is more a German style approach, rather not common in Turkey, maybe.
Definitely.
So a protective written submission is a kind of precautionary defense by potential competitors who are afraid that a patent owner or any other IP owner may ask for a preliminary injunction order against them. Yeah. So if there are any indications, yeah, they can file such a precautionary submission to the court, providing all arguments against validity, against infringement, maybe against urgency, just for the case that the patent owner may file such a request. And these protective written submissions will be collected in a centralized register, yeah, and any court, yeah, who is granting or is dealing with a preliminary injunction matter has to first look into this register whether the defendant in that case has provided a protective written submission to the court already. And then it will take this into account, and it often helps to avoid a court order ex parte, so without oral hearing. So it helps to at least go to an oral hearing and to extend the procedure.
But I think here there is something that we can ask, but we can add to what Kaya said, especially in the Turkish practice. Of course, we do not have the protective written submission system, but what we have is that in some cases, when there is a risk of infringement by any party, that party may file a request with the court for the declaration of non-infringement. This is a ruling and trial. Within the context of the same action, they may file an invalidity action and ask for a PI to prohibit or prevent the patent owner to execute or enforce its rights against them until the finalization of the trial. So this is something which puts the, let's say, the party which is under the threat of a patent infringement to defend itself against a possible infringement claim. So they are more on offensive side rather being on defensive side here.
So far, we draw a good macro picture from zero to here about the preliminary injunctions. But me and I hope 100% sure that our audience is also curious about some exciting cases, some interesting stories. I am sure that both of you had a great experiences in the courts about the different cases. Most of them are, I think, interesting cases, interesting stories in different industries. I know it is a confidential issue, but maybe without the naming any company or any individuals, we can talk about some interesting stories about preliminary injunction orders in both Turkey and Germany. What do you think about it?
I mean, there are certainly very interesting stories, but if you remember my initial remarks, I told you that preliminary injunctions in patent disputes are not so often, yeah, and preliminary injunctions in other IP sectors like trademarks, design rights, copyrights are the common standard even. Yeah, so it's rather more common to have preliminary injunction orders than going into proceedings on the merits. And in fact, I personally like more the soft IP preliminary injunctions. Yeah, because they are much more fun, and particularly on trade shows. Yeah, I can tell you one thing: my personal record in applying for a preliminary injunction order and obtaining the decision was 2 hours. So I filed the application and received the order within 2 hours, and this was quite fun. And then if you serve it on the trade show and collect some infringing IP infringing items, whenever I do this, I remember that I have an interesting and exciting job as an IP lawyer and litigator. Yeah, there are some trade shows even, yeah, where exhibitors already know me by face, yeah. So sometimes I hear them, hey, look, Kaya is coming, yeah. So this is interesting.
Kaya is coming in the trade
Yeah.
fairs. Like winter is coming, Kaya is coming in the trade fair. So 2 hours, it's amazing, right? So
Yes.
is it possible in Turkey, Oka?
I can't say that it's in 2 hours, especially when you have a patent infringement matter, because that's sometimes it's really.
Yeah, I have to admit this was not a patent case. So
Okay.
in patent cases, it lasts longer. Yeah, and you have to normally file even before the trade show begins. Yeah, so you have to collect information, evidence, affidavits. Full description of validity, full description of potential infringement, file it even before the trade show starts, and then you may get this preliminary injunction order in time so that you can serve it during the trade show. But on IP matters, which is much more easy to assess, yeah, so you just compare maybe the trademark or the one product to the other product, yeah. Then it's much easier to convince a court to immediately grant a decision. And my personal record, so this is not common standard, but my personal record was 2 hours.
Yeah, with regard to the soft IP, I think the Turkish courts may also be very quick to order, especially if there is a very, let's say, imminent risk, which would be, if there is any irreparable harm. So the courts can be, relatively quick. I cannot say by hours, but we can have quick decisions. With regard to the patents, I thought what I can tell here is I had a project for the border measures concerning the patented chemical compounds for a textile dye, and frankly speaking, usually, as you may know, it takes a long time to determine the infringement of a patent before the court even. But when we started a border measures program, and it was very interesting to see that we received several customs notifications concerning the patent infringement or the potential infringing products coming into Turkey. And that was very interesting. And I can say that the 80% of the suspended products were all infringing products. And we filed several PI requests before different IP courts in Istanbul.
and it was very similar to each other, where they stopped all, they suspended the release of those products, and the courts were convinced with the initial evidences and the test analysis, and I happily saw that it was the main, let's say, approach of the TRIPS agreement with regard to this type of infringement was, to secure the infringing product to stay at the border, not to enter into the trade channels. And it was very interesting to see that I think it was about, let's say, more than 10 PI requests were all accepted by different judges in Istanbul. And that was, I think my records were not hours, but just a few days.
That's really good to hear that stories in different jurisdictions. So I think our time is up. So it is so exciting to discuss this legal topic in a conversation mode. I know it's quite difficult to tell the details in just a sound, like a podcast session. It would be more convenient to show some of the figures, some of the the results, the some clauses from some agreements, some laws. But I really excited and have fun. Have a really informative session with you guys. Thank you so much for your great comments and opinions and insights about these preliminary injunctions. Do you have any other last words about this topic and the episode?
Yeah, maybe from my side first, and then I leave it to Okan. Thank you very much for having me here. It was a great pleasure to have some discussions with you, Okan, and with you, Mustafa. And yeah, I would like to greet everyone, all my friends, particularly in Turkey.
Thank you so much, and I will never forget this Kaya is coming sentence.
Yeah,
Okan?
likewise, I want to thank you really for this, let's say, it was my first podcast experience, which I enjoyed very much, and I hope to continue on other topics as well.
Exactly. I hope we will find this chance to record another episodes in different topics. Thank you so much for your contributions again.
Thank you.
Let me close the episodes. So it was so exciting to discuss this topic with our colleagues from Düsseldorf and Istanbul, Okan, Can, and Kaya Köklü. I'm really excited to host them at the same time, and you know that we will continue to record and publish our episodes, and particularly in the patent topics in the upcoming days. Please visit us on Spotify, Apple Podcast, and Google Podcast to listen the previous recorded episodes as well. I hope, and I'm looking forward to meet you again and in person as well. And also, I would like to say that our next episodes in different topics are coming in the upcoming weeks in the new year, and from now on I wish you, all of you, happy Christmas and happy New Year, and see you next time in the next topics. See you. Bye bye.